When Massachusetts judges are asked to determine or interpret the terms of a contract, so if there's a breach of contract lawsuit, the parties are going to argue about what the contract actually means. And often there's the contract itself, and then there's all this other stuff swirling around the contract, or just the precise language of the contract. There's all this other stuff that the parties usually want to bring in to put a spin on the contract, or to give some explanation for the intentions of the parties, whatever it may be. In the court, if that stuff is relevant, the court should take that stuff into consideration. So the Supreme Judicial Court has written, and I'm going to give you a couple quotes here. One's from the Supreme Judicial Court, the other's from the Mass Court of Appeals, and I'm going to write a blog post, and I'll put it in the comments below, or in the description below, so you can go to the text itself and then link to the court's opinions. So the court has said contract interpretation is largely an individualized process, with the conclusion in a particular case turning on the particular language used against the background of other indicia of the party's intentions. The scope of a party's obligations cannot be delineated by isolating words and interpreting them as though they stood alone. Not only must due weight be accorded to the immediate text, but no part of the contract is to be disregarded. So that's the Supreme Judicial Court, and the Appellate Court has added to that, saying parties to a written contract may, of course, alter it subsequently by oral modification, by their joint conduct, or ideally by a writing subscribed to by the persons to be bound. So what does this tell us? It tells us, number one, the number one most important thing is the contract and what it says. However, everything else that helps explain the contract and the intentions of the parties should be and can be considered by the court. So if you sign a contract, it's important, particularly or especially if it's a long-term contract, you should save all other documents related to that contract, because they may be useful later on if the contract ends up in litigation. So your records, your emails, your text messages, anything related to the contract or the business agreement, you should keep it, because the court should consider it in the future if there's ever a problem with the contract. So if you have any questions, go ahead and visit the blog post that I've written on this, or send me a message, or send me an email, and I'd be happy to talk to you.